Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
What do you do if you feel that you're being treated unfairly by your employer? The answer for some people would be to try an employment tribunal. But for the past 4 years, that's meant paying fees, which can be as high as nearly £3,000 if you appeal. This morning, ministers lost a landmark case brought by the union Unison. That means the government will have to pay back £32 million worth of lost fees. Ministers say charging will stop immediately. The country's top court ruled today that the fees are unlawful, as one of its judges, Lord Reid, explained.
The Supreme Court unanimously allows Unison's appeal. It holds that the fees order is unlawful under both domestic and EU law because it has the effect of preventing access to justice and is also discriminatory. The Court bases its conclusion that the fees are inconsistent with access to justice on a number of factors. One is that the fees have resulted in such a substantial and sustained fall in the number of claims being brought that it points to the conclusion that a significant number of people have found the fees unaffordable. The evidence establishes that the fees have had a particularly deterrent effect on claims of low monetary value or claims where no financial remedy is available. Indeed, the fees render it futile to bring many such claims, given the level of the fees relative to the amount of any financial award which might be obtained and the prospects of recovering any amount awarded.
Employment tribunals hear a wide range of claims by workers, including unfair dismissal, pay disputes and discrimination. Bringing a claim was free until July 2013, when the coalition government introduced fees which they said would choke off weak and vexatious claims. The fees are banded, so a claim for unpaid wages would cost a total of almost £400 if heard in a tribunal. For unfair dismissal, this rises to £1,200. Appeals against decision can cost a further £600. Joshua Rosenberg presents Law in Action here on BBC Radio 4. And Joshua, the court said that the fees discriminated against women. In what way?
The court did say that they were discriminatory in the sense that women were having to pay higher fees for particular types of claim, the more expensive one. But that was only Lady Hale dealing with a relatively minor point. The case was brought on the basis of discrimination, but what you heard Lord Reid say there was that he and the other judges who agreed with him all granted the trade union's claim on a much broader constitutional basis. This is a really important constitutional decision by Lord Reid, one of the two Scottish judges and a rising star in the Supreme Court. And he decided the case, and as I say, all the other justices agreed with him on the basis that the constitutional right of access to the courts is inherent in the rule of law. And this wasn't just a defeat for the government in financial terms, it was a defeat for the government in the way that it has been thinking, because Lord Reid was very sniffy about people who talk about the idea that courts and tribunals are providers of services to the users who appear before them, and those services are of use only to those users and the lawyers. It's much, much broader than that. What's been the effect of the fees since they were introduced? Well, as you heard Lord Reid say, it put people off bringing cases, not just because these are large sums of money for people who in many cases have lost their jobs, but because in many cases, even if you bring the case and when you can't be sure of getting the money back from your employer, there are all sorts of problems in enforcing it. And also some of the claims are not actually worth a great deal in financial terms, and you really wouldn't pay a fee unless you could be absolutely sure you were going to recover the money you're claiming and the costs that you're getting. So it's put people off, and it's not even raised as much money as the government intended. It's been a major problem for the government, and as a piece of policy is one that doesn't seem to have worked at all, but as a constitutional matter, by depriving people of access to the courts and therefore undermining the rule of law, it's a major mistake for the government, which the government is now apparently rectifying. And rectifying in what way? What's this going to mean for previous claimants? Well, that's the point, because it's all very well to say you're going to give people back the money that they paid on these fees. The real problem is, of course, these people who were deterred from bringing claims in the first place. Now, I really don't think it's going to be possible for them to bring claims out of time. The moment has lost over the past 4 years. There are plenty of people who would have thought of suing over losing their jobs or some other problem at work, and they've simply given up that chance, and I don't see how that's going to come back.
Joshua Rosenberg, thank you. Well, earlier I spoke to two workers who were put off from pursuing an employment tribunal case because of the costs involved. First, motorcyclist courier Ronnie DeAndron.
I've been doing the same work for this company for the past 6 years, and I wanted to become an employee because, you know, as everybody knows, as employee have a lot more rules into place to protect them, and that's what I wanted. You know, regardless of how much I was going to earn, I just wanted to feel safe in my workplace and feel like I was progressing, and I would have the protection to plan life.
So did you think about going to an employment tribunal?
Yes, but I knew without representation and money, I wouldn't be able to get nowhere with it.
Of course, for the past 4 years, people have had to pay a fee to go to a tribunal. Did that put you off?
A lot, yeah. If not for the unions, I wouldn't be able to afford it. It's so expensive to be able to go to court, and I think I'm not alone in this. A lot of people are put off to take any action against an employer if they have to pay so much.
Ronnie DeAndrande. Secondly, teaching assistant Clara Mason.
It came to our attention that we was being not paid the right annual leave. So obviously we then put into a case which led to up to 442 members joining the case.
And did the idea of there being fees for an employment tribunal, did that affect you at all?
Well, yes. When we asked members to fill out a form, for us, we have to look at the form and it does state about fees. And that was one thing looking at it for me, myself, was would I be able to afford to pay this? But with Unison, they pay those fees for us on our behalf. So it meant that we was able to, you know, go ahead with the claim without the worry of a financial burden for us.
So if your fees hadn't been paid, where would that have left you?
I wouldn't have been able to pursue my claim, and I don't think many of the other members in that claim would have been able to pursue it because we are low-paid members. We only work term time only, so our pay is quite low, and majority of us are female. So for us, we're parents or, you know, grandparents, and it is a struggle to find extra money on top of your monthly income.
So what do you think about today's ruling?
It's absolutely brilliant, not just for Unison members, but for people that work within various employers who are not a part of a trade union. It means so much for them because actually, without having to pay the fees, now they're able to then go against their employers if there is an issue. So it's a great victory for everyone.
But not everyone does see it like that. What impact will an increase in tribunals have on companies? The Institute of Directors said this morning that businesses across the country will be extremely alarmed by the Supreme Court's judgment. Charlie Mullins is the Managing Director of Pimlico Plumbers and joins me now. What's your view of the ruling?
Quite honestly, Martha, I think it's the worst decision to businesses to happen since we voted to leave the EU. Absolutely disgraceful. As you're probably aware, claims cut down by 79% since 2000. Since 2013, they peaked, I think, at 7,500 claims per year, and it's down to 1,500 at the moment. This is going to stop people from employing people because, let's not kid anybody, many of these people that take a company to tribunal, they're in it just to see what they can get out of it.
Well, they would argue that they're just going to court to get their rights, that they should have access to justice, and the fact that the claims have gone down means that people aren't getting the
difference here, Martha, you're talking to someone that employs 350 people, and if you've got an issue at work, you should be able to sort it out yourself. If somebody's unhappy to work for you or with you, and we can't agree it, if they're unhappy, they should move on. I'm telling you now, this is the worst decision to happen. We've got unemployment down to, I think, 1.5 million. When this law was in, it was up to nearly 3 million. I'm telling you now, it's a bad mistake that's happened, and it needs rectifying.
But people may not be in a position to move on. They may enjoy working for the company, but feel that they're discriminated against because they're a woman or a part-time worker.
I've got to tell you, you know, I've had one tribunal case taken against me in 39 years, right? This is going to open up the floodgates, and many people, I'm telling you, it's like this claim for insurance in a crashes. They crash a car and claim. This is going to open the floodgates for the same thing. I'm telling you now, it's a bad, bad decision. And you know, many employers are very fair with people, and they'll sort the problem out. If they're a good employer...
Well, if they're fair with people, aren't they maybe not be liable for claims in an employment tribunal then?
Well, yeah, but what I'm trying to say is they take a chance. A lot of people take a chance. Look, if they want to simplify it here, what they should say is it should go to court, and the person who takes it to court, like we would have to take to court and pay the fees, then fees should be returnable if they win the case, and by rights, the employer can actually pay them fees back.
But you're a company, as you said, you employ 350 people. Aren't you in a different financial position from somebody who works from you who may not be able to afford those fees or worry about not getting them back?
I get that side of it, but what I'm trying to say is, I'm still saying to you is that many people that go to these tribunals, they're busybodies, they're troublemakers, they have an history of going to tribunals. The average good worker wants to get on with the job. If they've got a minor issue, look, if it's a major issue, of course it needs to go to a tribunal. But most of these things are very minor. And I'm saying to you, the fact that it cut down from 7,500 to 1,500, it proves the point how beneficial it is.
But the balance between successful claims and unsuccessful claims didn't actually change, which suggests that perhaps when you look at the proportion, that the ones that were, inverted commas, vexatious, weren't as many as people thought before this reform was brought in.
Well, I'm saying to you, many of these claims are miscellaneous, or whatever the word is, malicious claims. And I'm saying to you, this is opening the floodgates. I mean, unemployment hasn't gone down to 1.5 million just by itself. It's gone down because companies are more happy and more grateful to take on people, knowing that they're not going to have all these people that just want to take us to the courts.
Charlie Mullins from Pimlico Plumbers, thank you. Well, let's talk now to Dave Prentice, who's been listening to that General Secretary of one of the country's biggest unions, Unison, which represents 1.3 million workers, and in fact brought the case that ended up with this judgment. Well, you heard the very forceful arguments there that this could lead to loss of jobs.
Well, of course it won't. Let's get the thing in perspective. What the Supreme Court has said very, very clearly today is that the government has acted unlawfully in bringing in these fees. It's acted unlawfully in terms of common law, it's acted unlawfully in terms of constitutional law, it's even acted in terms of infringing Magna Carta of 1215 and also European law. The fees are unlawful, and all that's been decided today is the fees are unlawful and therefore they've got to be set aside, and people have got to be reimbursed the unlawful fees that they're being made to pay.
But you heard Charlie Mullins say that that's going to open floodgates there for people who are going to bring cases to see what they can get.
But let's get in perspective. Charlie refers to 39 years that he's been in business, only one case taken. These fees have only been there for 4 years. So for 34 years, when we didn't have the fees, these tribunals came in over 50 years ago. You have operated and nobody's taken a case. When fees were not charged. And what is happening is that people are being excluded from justice. They do not have access to justice. And that is unlawful in doing that. Low-paid workers, mainly women, mainly in discrimination cases, and it could be race discrimination, it can be over equal pay itself. It can be over unfair dismissal, but you can only claim unfair dismissal after 2 years. Yeah, look, it's not these people that you're talking about.
David, I'm not saying that don't take people to tribunal. All I'm saying is that they should pay the fee and it should be reimbursed if they win the case. I mean, you're talking about rights to justice. We just had a couple that couldn't get fees to save their child. So, you know, where's the justice in that? I mean, I'm telling you now, David, you know and I know this will open the floodgates. And unfortunately, I'm telling you straight here, I'm in the business, so I know what I'm talking about. It could even send this country into recession. What with the Brexit and now this?
OK, well, let's get Dave Prentice to answer.
So we avoid recession by acting illegally, unlawfully in this country. We believe in the rule of law. Nothing to do with the European Union. This is British law going back to Magna Carta. And that is what the Supreme Court of the United Kingdom has decided today. And when you look and talk, you're talking about frivolous cases. The Supreme Court itself showed that the number of frivolous cases has not reduced since fees came in. There's still as many frivolous. Okay. What has reduced are the genuine claims, because people won't bear the risk. Low-paid workers cannot afford these fees.
OK, well, Charlie Mullins clearly represents just one business, but the Institute directors say a third of businesses believe that dismissal procedures has deterred them from recruiting new employees because they're worried that if they take on somebody, if it doesn't work out, they'll end up in a dismissal case.
Well, of course, if the dismissal is fair, they've got nothing to worry about. If you're a good employer And I deal with tens of thousands of employers. And good employers, they want good regulation because they're undercut by the cowboys who abuse workers' rights. There's no new rights have been established in this. The rights have been there. This issue is about how are they enforced. And by having to pay for tribunals, it's stopped the enforcement of rights that are there. And that is why the Supreme Court has reached the decision it has.
Do you think it's going to lead to a rise in cases now?
There will be a rise in cases of genuine cases. The number of frivolous cases will remain the same.
How can you say
they have not gone up or down throughout the 4 years, frivolous cases. Not me saying it. 8 of the most senior judges of the land have said.
So why has the cases gone down from 7,500 to 1,500?
Because people have got real cases, and a lot of it don't involve much money. It might be about rest breaks. It might be about unlawful deductions from pay. They will not bear the risk of having to pay out £1,200.
But them things should be sorted amicably. But what I'm saying here, I don't want to leave the EU, but at least when we leave the EU, they do away with this stupid law.
Okay,
no,
just before we come to...
This has nothing to do with the EU.
What are you talking about? Of course it's to do with the EU. It's an EU law.
This is UK legislation.
It's an EU
going
law,
back
okay,
to
well,
Magna
since you,
Carta.
okay, well, all right.
I'm sorry, mate.
Okay, well, since you've mentioned the EU, I did want to ask you before we let you go, Dave Prentice, about this big internal debate going on, the union movement within Labour about Brexit. Do you agree with Jeremy Corbyn's views that the UK should come out of the single market when we leave?
Well, we've got to look at all the issues involved. My union believed that we should have voted to remain within the European Union, and I'll say that quite openly. No, we're not. That won't happen. We're a democratic society. We move forward.
We move forward from that, but the discussions about the single market. Do you think Jeremy Corbyn was right to rule out staying in the single market?
I'm concerned about public services, public service workers. The crash of 2007.
I understand but my answer to my question.
I'll answer the question. The crash of 2007 has been borne by low-paid public service workers.
Understand your view on that, but I'm asking you about the single market.
If this goes wrong, they will bear the cost.
Should we be staying in the single market?
We should be saying we should be looking for an agreement that allows us to remain with tariff-free and on similar regulations to the rest of Europe. It'd be a nonsense to do otherwise.
So
it's
inside
our biggest
the single
trading
market.
partner.
Ask me the question, Martha.
Well,
of course we should be staying here. Jeremy Corbyn's a twat, isn't he?
Well, we'll definitely leave it there on that. So apologies to Jeremy Corbyn for the language used. Dave Prentice, Charlie Mullins, thank you both.